You're in the know with Mary Ubel. We're here at Patton & Patton, attorneys at law, to discuss the differences between wills, trust, probate, to understand how to save time and money. You're in the know with Mary Ubel.
It's very important to have a will. It's also important in terms of being able to educate you about what that all means, about how to title property. Because if you were, for example, to just use a form will, you really wouldn't understand what you were doing. I mean, you wouldn't understand all of the different things you need to know about what happens to your property under Kansas law if you don't have a will. There are lots of things that you can learn when you go to see an attorney about how to title property, even to title property so that you don't have to have a probate. You can title your property in joint tenancy with right or survivorship, for example. And those are things you can learn when you go to see an attorney, whereas if you're just looking at a form, it doesn't educate you about all of those different things and what your different options are.
What's the difference between a will and a trust?
Well, a will operates so that your property passes through a probate proceeding. A trust operates so that you avoid the probate proceeding. Trusts are usually a little more complex, and so some people don't like them because of the complexity. But they basically put all of the property in the name of the trust rather than in the individual's name, and we call that the individual a grantor. And they put all the property in the name of the trust, a living trust, and then you have a trustee after that person is gone who can follow your terms of the trust and distribute the property to children or grandchildren or whatever the terms of the trust say, or to a spouse. And the trustee then distributes the property without a probate.
Are there different levels of, is there like a simple will, a simple trust versus,
okay? There's a simple will, usually is less expensive. It doesn't have as many provisions in terms of what's going to happen if I have 3 children and I want to preserve a trust for them or something like that. A simple will just says, the property's going to go to the spouse, and then when the spouse may be gone, then the children would get the property. That's another reason why it's good to have a will, is because under what's called intestate succession or succession without a will, half the property goes to the spouse and the other half goes to the children. Well, a lot of times a spouse, you really want to take care of your spouse first, because your children are working and they have jobs and those kinds of things, but your spouse really needs to make sure all the assets go to him or her while she's alive, and then when she's gone, that's when you generally want the property to pass to the kids. And so a will allows you to do that. It's also good to have a will because you want to be able to appoint a guardian for your kids. For example, if you have young children, you want to be able to designate who you want to take care of them, because otherwise you may have family members that are fighting about who should take care of the kids. You may have, it just creates a tension there in terms of who's going to take care of the kids, whereas if you work that out and designate it in a will, there's no fight about it. And also the judge is most likely to appoint whoever you specify in your will, and generally that's what happens.
And what about a trust?
A trust, the same thing. You can say, I want this person to be the guardian of my children, and that you can do that. A trust also is a nice way to provide, for example, if you have one child who's still going to be a minor and maybe needs an education, you can put terms in your trust to provide for that first, rather than just having all of the property just go, straight to the kids. That one who's still in college may need the assets more than the older children who are out having jobs, and you can provide for that in your trust.
So there's a great importance here to be educated.
There is, because there are a lot of different options that you have to think about, and by going to see an attorney can talk about those options, really discuss what do you, how soon do you want this property to pass to your kids? Do you want them to, at 18, to get $30,000? Well, they're probably not going to be very wise at that age, and you can provide for that money to be held in trust until they're older. and can be more wise with the use of their property.
And saving time and money.
Right,
and
exactly.
Through coming to an attorney, you can
Yes.
educate
Yeah, and
provide that knowledge.
I've had a lot of situations where people didn't see an attorney ahead of time, and they see me after the fact, and we spend a lot of time doing things that we could have very easily taken care of in a will, that now we're having to go back and retitle property and get consent from heirs and things like that takes
Right.
more time because you didn't take that, few minutes to set out a will that made it very clear and easy for how property's going to pass.
What is probate?
A probate is a formal proceeding in the court. It's all of the records are public, and it's a process by which you take the title to the property as it is before the person passes away, and it formally puts that property into the name of the people who are inheriting it, of the heirs.
Mm-hmm.
And the title to property through a probate, the nice thing about a probate is that you settle all of the debts through the process of the probate. And that can be a situation where you have a certain amount of time for the creditors to file their claims against the estate, and then if they don't file the claims within that period of time, they're barred from claiming any money from the estate. But that also means that because there's a certain time period that a creditor has to file, it takes about a year to finish a probate, and that can take even longer if you have a lot of assets or if there are people that are fighting during the probate. But it is a formal process where you go and you ask the judge to approve what's done, which is a nice advantage of probate because it finalizes all the decisions, and it makes it very clear that the judge has looked over what has been proposed and approves it, and then it's finalized in that way.
What's a power of attorney or
There is a durable power of attorney and a regular power of attorney. For example, if I'm going on vacation, I may want you to watch my kids or something, and I'll give you a power of attorney to take care of my kids while I'm gone, or to make medical decisions, because I'm gone. That's a regular power of attorney, but it's not good if you're incapacitated. A durable power of attorney is a power of attorney that I give to another person, usually a spouse or a child, so that they can act for me if I'm incapacitated. And that's very important to do if you have, an older person who may have a stroke. I mean, there are a lot of things that can happen suddenly. But if you have a durable power of attorney that's written up ahead of time, then it's very easy to take care of all of their finances, file their income taxes, make decisions for them in terms of health care. You may have a durable power of attorney for health care and a durable power of attorney for finances, which allows you to help take care of business for that person who's incapacitated during their period of incapacity.
So if I call and make an appointment, what should I bring with me during my first appointment? What would you recommend?
Usually you don't need to bring anything with you for the first appointment. We'll sit down and talk about what documents you have. I may want to look at insurance policies, and you will bring those back maybe a second time. But the first time, I get to know what kinds of assets you have, and then I can say, I really want to see that what your beneficiary designation is on your IRA or whatever, because we talk about what assets you have, and then I know what to ask for. And then also, if you have a will already, you can bring that will in. I can look it over and make sure it's doing what you want it to do, and can give you advice as to whether you may just need an amendment to the will called a codicil, or if you want to redo your will in order to update it and get it to do what you want it to do. Because at different stages of your life, you may want a will to do, like I talked about, you may want a trust to protect your minor children or to appoint a guardian. Well, when you're older, those things aren't as important to you. Your kids are old enough that they're going to be able to handle the money when it goes to them, or you may be more concerned about taking care of a spouse if they're incapacitated and those kinds of things.